Hi, this is Curt and welcome to another edition of Fire Law Roundup.
Okay, let's finish up. This is a great case. Let's finish up in Alabama. We don't get to Alabama a lot. Alabama, and this is the right holding. It's so let me start with, before I get into this, and understanding what vicarious liability is. So vicarious liability is the liability of the employer for the employee's acts. And Curt, you froze again. So it's the liability of the employer for the employee's acts, but you have to prove that the employee was liable. Now, that's not to say that the employer can't be separately liable on its own, but this is vicarious liability. The employer is liable for the acts of the employee. You got to prove the employee was liable first. So with that said, you can imagine, here's what happened. So the Supreme Court of Alabama, which I think is the highest court in Alabama, has refused at the moment to take an appeal, to listen to an appeal in a wrongful death suit. And they said that the trial court, I'm going to go through the facts because these are really interesting, and we could teach a class on these facts, right? But it said that the trial court has to first determine the liability of the firefighter, the individual firefighter, before the fire department or the county can be decided, right? Vicarious liability. And so they send it back. Listen to the facts, everyone, because these are super interesting facts. I have so many questions. So in June of 17, you've got somebody driving and they flip and they go into a creek, right? A couple of passing by motorists pull one of the people in the car out. And a bystander, who also happens to be a volunteer firefighter in another department, starts performing CPR. Good job. At some point, the county EMS is notified and starts responding. Not yet here by the time this happens. So now another firefighter, Geis, if I pronounce his name right, he heard the accident on a radio, which the fire department gave to him. So he's listening on a radio and decided, because no one was nearby, he's out of his district and it's not their call, but he says, since nobody was nearby, I decided to go to the scene. Okay, I can't fault him for that, right? He's doing the right thing. And he wanted to assist the paramedics, even though he wasn't in their service area and his department had not been dispatched, right? So this right away to me is, I'm curious, what are the policies on responding to somebody else's calls? Okay, once he arrived, the bystander who's performing CPR, I'm presuming because he was tired, asks him to take over, Geis to take over. And Geis says no. Instead, Geis says that you should terminate rescue efforts, stop doing CPR, and then Geis goes in to help with rescue of other people. 5 minutes after the bystander does in fact stop performing CPR, which starts my question, what's the liability of that person who stops performing CPR? If he's tired, obviously no liability, right? You can't do it. But the county paramedics arrive. Now listen to what you had quoted them saying. They examined the victim and found that she was warm to the touch, had a pulse, and had responsive pupils. My question is, and I'm assuming the answer is no, was she not breathing, right? She has a pulse. I mean, you can have a pulse while you're not breathing, not for long, but right, for some time. In any event, as a result, the paramedics performed CPR until she returned spontaneous circulation. That's what I don't understand. She had a pulse, but spontaneous circulation, something's very strange. In any event, she's transported but dies as a result of anoxic encephalopathy. It sounds to me like she was bitten by a mosquito, but I don't think that's right. She's brain dead. She's brain dead. In any event, so there's all these defenses, right? And I have a lot of questions for more, but the court says, listen, assuming that Geis was acting in his capacity as a volunteer firefighter, would he be immune, right? Would there be any liability? If Geis acted wantonly, so not carefully, then he might not be liable for his wantonness, right? So there's all these questions about the liability of that individual. Now, I got to tell you, if you're the municipality, you have a hard choice to make. You can either say, we welcome our volunteers going out and doing things. He knew about it because of our radio. He clearly acted. I don't know why anyone listened to him, but this person listened to him and stopped CPR, but nonetheless he did. So the question is, and this is going to be a pretty much nationwide decision as far as I'm concerned, because determining whether somebody who's out of their service area listens to the page, is not dispatched, and goes and performs services, is that within their scope of duty? And I was trying to think of this in terms of New York, because you and I both draft policies for the departments. I don't have a policy that I would ever think of saying it's okay or not, except in New York. New York provides, and I want to throw this out, maybe there's other things similar. New York provides comp benefits if somebody is injured outside of their area, responds to a scene or happens upon a scene and gets injured, like they happen upon a motor vehicle accident and they get hit by a car. They would be covered by the home insurance, which makes it sound like they are authorizing you, right? Doesn't mean it's your duty, but they're authorizing you to be compensated. That would be a factor. So I question, why would this person be deemed to be acting in the scope of their duty as a firefighter if they go to somebody else's scene? And maybe there's some type of policy, maybe there's some type of benefit, but in any event, the court has the same question. The court wants to say, look, we're an appeals court. We don't decide issues in the first instance. So trial court, you should have decided whether he was acting in the scope of his duty, if he was acting carelessly, if he was acting reasonably, and then we can decide everything else. But I think that question is going to have so many long-term ramifications in the fire service. I don't know. Have you seen a case like this where there's that type of question?
There's a few out there, but again, regardless of what happened, and I'll go back to my analogy with a close play at second base. If we have one runner slides into second base and they're safe, that doesn't mean the next runner that slides into second base is going to be safe. It's right. A different play. So you have all these different things. What we've got here is that issue, the inescapable issue of duty to act. And when does someone have a duty to act? And you can say, this guy Juice, he didn't have any duty to act. Okay, fine. But by stopping and starting to render aid, you can then sort of create that duty to act. But how far does that duty go? And I use the metaphor of a slippery slope, because once you say somebody has a duty to act, okay, well, what exactly is it? Does he have a duty to check a pulse? Does he have a duty to check the pupils? Does he have a duty to start CPR? Does he have a duty to do rescue breathing? Right. And how far does it go?
And and here, when you as a person assume a duty, that doesn't mean that you've necessarily assumed it on behalf of your municipality. You may have a duty, but doesn't mean that your municipality has that duty. I'm not sure you could bind your municipality to a duty that's not part of your normal responses.
Yeah. I mean, there's a lot of different factual questions here. And I think the common law rule, as hard as it is, the common law rule is that absent a relationship or some sort of statutory creation of a duty, no one has a legal duty to render aid.
Right.
I think that's now. Here's the other side. I don't know if you recall this. I live in one of the 4 states that have a statutory duty to act. So in Rhode Island,
isn't it mostly of notification? It doesn't mean you have to render help.
It doesn't say that. It doesn't say that. It says you have a legal duty to render aid so long as you can do so without peril to yourself.
Okay.
Okay. So, and I think the way that that's interpreted very often, like you can't do CPR on someone. Well, I guess you could do the chest compressions, but you can't do mouth to mouth without peril to yourself.
So stop there for a second, because that leads to my factual questions, which the court never raised. But imagine this scenario. Right now, we're just playing with the fun of facts. But if this was my defense, what I would be saying is, wait a minute, she had a pulse. Yeah. We don't do respiratory breathing. And she had a pulse. So at that point, there's nothing more we could do. So we decided, for the good of the entire scene, go try to help the victims. She's got a pulse. I'm not going to do rescue breathing. Not even the AHA, right, or ARC teach rescue breathing anymore. It's just 31, 32 compressions, whatever, until you get a bag valve mask or a pocket mask or something, but no physical mouth to mouth anymore. And so this person may have done everything possible. I don't know if I'm making that fact up, other than the report is she had a pulse. So if she wasn't breathing, there was nothing he could have done at all. And his decision, now let's go in, right? So maybe, and so here's the other thing. If he said, hey, forget the patient. Now this is like shooting a person who's dead and believing and getting charged with a murder. You think you killed them, but they're dead. So here's why I'm bringing this up. And Curt, you're frozen again. So if this person thought she was dead, right? Geist, Juice, whatever his name is, thinks the victim is dead, but really she's got a pulse. Now he hasn't hurt her. His belief hasn't hurt her, and there's nothing more he could do. He then says, stop CPR. Let's assume he says, stop CPR. She's dead. Well, she's got a pulse. There's nothing more she could do. You're not going to keep doing compressions. So I would be taking the argument, and again, goes back to, because you and I are firefighters and rescue personnel, we would think of this stuff. But for some reason, the defense attorney didn't move to dismiss based on he didn't do anything wrong. Right off the beginning, I'd say did nothing wrong. And maybe that's a question of fact. So it was too early in the case to do that.
And
but
I
would
say,
say
there's a lot of questions of fact. As you were going through the facts I started looking at it maybe differently than I had before, but I said, how do you know for sure that the person who started CPR wasn't doing CPR on someone who didn't need CPR?
Right. And she had a pulse. I mean,
that's what I'm saying.
The paramedics
and her pupils are reactive.
Yeah.
I can't remember ever doing CPR on someone whose pupils were reactive. That's so at any rate, I think there's a lot of factual questions. The plaintiffs in the case have the burden of proof. So chances are at trial, they're going to have a very difficult time saying that he has some sort of liability here.
I think so too.
So when this case comes back up, and it will probably, no doubt, unless it's settled, it's going to come back up to the Alabama Supreme Court. But there's a lot of factual questions on legal duty, on standard of care. What was the standard of care, and then was the standard of care breached?
Yeah, I mean, prove she had a pulse. Prove she didn't have a pulse. Later, she had a pulse. She clearly had it. She didn't spontaneously regain a pulse. She either always had it, or it was
reactive pupils. I mean, I don't know.
CPR doesn't cause you to regain your pulse, right? Yeah. CPR keeps you from being brain dead, but only drugs, chemicals, right, and defibrillation bring back your pulse, to my 30 years of knowledge. So I've never seen CPR except on TV, necessarily return somebody from a VFib or VTAC into, right, doesn't correct the electrical problem. I want to say this, as we're done with this case and we're done with the cases, I want to let you know, because it's public information. So there is a lawsuit now against the city of New York based on actions or non-actions of two of my clients. And that I will make sure it does, but I'm sure it will appear in your radar. It was just filed in Kings County. But here's the brief of it. And it's so relevant. It's almost like this. The short of it is, two FDNY EMTs, my clients, were dispatched to a scene with a person vomiting out his, a lot covered in vomit, whatever, coming out his nose, apparently was in the street. They arrived, there's nobody there. You could see him on video on a street cam walking around. There's nobody there. Somebody comes from a couple stores down, says, hey, come over here, and points to this guy. Here's where the facts get crazy, but he's either in a chair or on a couch. It matters. Either it's covered with vomit or he's not, matters. But the EMTs walk in and the people say, hey, we want this guy out of the store. And he's snoring, not agonal snoring, says my guys, but actually sleeping and appears to be drunk. So they lift his arm, they feel his pulse. They're like, he's got a pulse. He pulls back his arm, right? And kind of a leave me alone type of manner, not in medical distress, just leave me alone. And they say, listen, it's a police matter. You got to call the police. Do you want us to call? They say, we'll call. Right. So 20 minutes later, the guy's dead. And my question, I don't think it's the same person. I think it's one hell of a coincidence, but the way they describe it, in any event, as you would imagine, this turns into a lawsuit. Now, they found a bunch of heroin in his pocket at the hospital. But the question is, how does this happen? What's the liability? All that. the city of New York investigates and doesn't impose any charges, but then apparently refers it to the state where I'm presently defending charges. And now this lawsuit gets filed. This is going to be a very interesting case, clearly, because we didn't believe this person was a patient. Right. And we looked quickly, and it's going to open a question of liability in that case, not to get too far down that, because it's very much like this case, except they're not bystanders. Right. But it's going to come down to what was their duty when they don't think it's a patient. Right. It wasn't who they were called for. Was it a patient or not? So we'll get more into this. As I see what my role is, I can later determine more. I have the penalty in front of the state part, but now there's the wrongful death suit, which I'm hopefully not going to be involved in, but we'll see, too far away. But when I see these types of cases about EMTs getting into trouble for their acts, I think, the first question I have is, were they acting in good faith or not? Generally, this person, like getting back to Geis, right? He responds to the call. He didn't have to go. He goes out of the, I presume he's not just an adrenaline junkie. Maybe he is, maybe he's not, but he goes and he even after CPR goes, or refusing to do CPR, he goes into the water to try to rescue people. Maybe he's a glory hound, maybe he's not, but to say someone like that's acting in bad faith is a little difficult when they're at least trying to pay attention. So this whole issue with the liability of EMTs for things that happen, people don't get. We're in a very quick situation. We have to make a very quick judgment, which the law usually protects us on. And unless we can prove a bad motive, why we didn't want to do something, why are all these EMTs just ending up liable, or their employers? So anyway, it'll come across your desk, I'm sure, in the next couple of days.
Difficult case. And also, like you said, you were getting to an interesting point in your original fact pattern where you're treating one person, but there's other people that also need to at least be evaluated. So you leave this person, say, no, I'm not going to do CPR. I got to, at least triage the other people first. And, somebody can take issue with that. They pick you apart Monday morning quarterback and, no, you should have stayed with my husband, or you should have stayed here, and not because you really, turns out you weren't needed for those other things. So whatever it may be. I
mean, this guy to say, Geis or whatever, to say, stop CPR, let's go get the people out of the water. Yeah. I would have said that too. This person was a black tag, or maybe not. Right, on the MCI, but let's at least see if there's viable victims in the water and get them out. I don't disagree with his choice based on what he was told. He might have said, hey, is there anybody else? Yeah, there's a couple of people still stuck in the car. What the heck are we doing on a dead person? Let's go see if we can save them. I don't disagree with it. And that's my case that I just talked about in Kings County. And that's what just gets me a little nuts, right? Because these liabilities of EMTs who very well may be acting in good faith. And now you put them through this. And I got to tell you, the last 4 cases I've had just like this, where somebody sues them or the health department comes after them, they're always resigning. They're like, I'm done. I didn't sign up for this. I signed up to do good things, and this is the position I'm in. This is not like a police officer issue with excessive force or whatever. This is just excessive trying to make a decision. So I can't stand that. But anyway, a lot of those cases, I probably have 3 of them right now, which are all EMT good faith cases where somebody's saying, well, you didn't do what you should have done. And they're like, well, we didn't think we had to, or we made another decision, or we weighed our options, or people love, even these regulators and courts love, second guessing what we had no time to decide. It really bothers me. But that's how we make our living, I guess.